termination from employees' final pay if an employee doesn't give sufficient notice. And what does happen if an employee resigns without giving sufficient notice? Welcome back, or just welcome if you're new here. I'm Carmen. I'm an employment relations practitioner, and I'm also the director of Free Employment Relations. I have included a list of my credentials in the description box below to give you some peace of mind around the content that I share. Today's topic is about whether or not an employer can deduct from an employee's final pay their notice if the employee did not give sufficient notice. Or answering employees' questions is what can happen if they do not work out or give sufficient notice upon resignation. I have a video that is all about notice of termination. I've linked that down below. So if you haven't watched that video, I would recommend watching that first and then watching this video to get a holistic understanding of notice of termination. And in that video, I address what happens if employers do not give sufficient notice to employees when terminating the employment relationship. I'm not going to repeat the information from that video in today's video. So in today's video, I'm just going to discuss what happens when an employee does not give sufficient notice upon resignation. Who is this video for and who can benefit from it? Firstly, employers who are dealing with a situation where they have an employee or employees that resign without giving sufficient notice as per the requirements of the basic conditions or their contract. Secondly, employees who have the intention to resign without giving sufficient notice. And finally, practitioners who work with the employment relationship, including employment relations practitioners, labor relations practitioners, industrial relations practitioners, HR practitioners, as well as payroll practitioners. Quite often when I get this scenario, when I ask my clients or employers why they did or why they handled this in a particular way, their response is because my payroll or my bookkeeper said that I could do X, Y, and Z. I'll discuss exactly what X, Y, and Z is in a moment and the technicalities around that. And that's also just why I want to highlight that this video is beneficial for practitioners such as payroll practitioners who deal with the final payments that are made to employees on termination of employment, and not just for employment relations practitioners. And just a reminder that even though something is done commonly in practice, doesn't necessarily mean that it is lawful or compliant or best practices or even a good practice to be doing it. My first disclaimer for today's video is that the information contained in this video is going to come out of the Basic Conditions of Employment Act. What that means is if your industry falls under a bargaining council or a sectoral determination, you can still watch this video, but you will need to supplement the information in this video with the information contained either in your collective agreement if it is a bargaining council that has jurisdiction, or in the sectoral determination if your industry falls under one of the industries that have sectoral determinations. Disclaimer number 2. Although I provide a lot of information in these videos, I'm not able to cover every single scenario, every exception to the rule, and therefore a reminder that these videos are for educational purposes only. Contact a professional if you need to. On to today's topic, and I see this very frequently, probably about once a week, where employees will resign without giving sufficient notice and employers will deduct their notice period from their final pay. There might even be a clause in the contract of employment that states should an employee not give sufficient notice as is required by the contract or the basic conditions of employment, whichever one is applicable, then the employer will have the right to deduct said notice period from the employee's final pay. There's a couple of things that I would like to unpack here, and in today's video I'm going to discuss all of the technicalities around a clause like that and the action of deducting an employee's notice pay from their final pay. What do I mean when I say sufficient notice? Again, most of the information around the notice period is contained in the previous video that I made, specifically around notice of termination. But for this video, when I say an employee did not give or did give sufficient notice, what I'm referring to is, firstly, if there's a contractual agreement that the parties have lengthened the notice period to be longer than that which is contained in the basic conditions of employment, then that notice period. Or alternatively, if there was no such agreement, that at a minimum the notice period is that which is stated in the basic conditions of employment. An important thing that I would like to highlight is that very seldomly when I give through guidelines are there hard rules to be applied in a black and white manner. So here's a general rule which might prevent some of the misapplications that happen. And that is, just because something's in the contract of employment does not necessarily mean that it is compliant and does not necessarily mean that it can be enforced. When it comes to the labor legislation will always trump the contract of employment. Therefore, if the contract of employment states something that is contrary to the labor legislation, then that particular clause cannot be fairly enforced. And the parties will need to revert back to what the legislation says is and is not allowed. So the previous clause that I mentioned, the one that states some variation of the employer will have the right to deduct the notice pay from the employee's final remuneration if the employee does not give sufficient notice. Just because that clause is in the contract of employment does not necessarily mean that it can be enforced. Then the question arises, why do we see it in so many contracts of employment? The first reason is that the person who drafted the contract of employment believes that it can be enforced and believes that employers can deduct the notice pay from an employee's final pay. I'm going to discuss the ins and outs of that in this video, and you can decide for yourself whether or not that clause is enforceable. The second reason why that might be in a contract of employment is because the person drafting the contract of employment may not believe that it is enforceable, but they put it in there to deter employees from not giving sufficient notice as per the contract. The concern I have with the second reason for including that is that when employers look at their contract, they do not necessarily know why the practitioner included specific clauses or not, or it might not have been made clear to the employer that that clause is not necessarily enforceable, and then an employer will enforce it, and the rationale for that will be, well, it says so in my contract of employment. So let's clear up some of the misunderstandings, and I'm going to take you through the applicable legislation for you to decide whether or not that specific clause is enforceable. When we discuss notice of termination, usually we would look to Chapter 5 of the Basic Conditions of Employment under Section 37 and 38. Those sections are comprehensively covered in the previous video. However, to answer today's question, we're not going to be looking at notice of termination per se, but instead I'm going to be discussing Section 34, which relates to deductions. Section 34, Deductions and other acts concerning remuneration. 34.1. An employer may not make any deduction from an employer's remuneration unless A. Subject to subsection 2, the employee in writing agrees to the deduction in respect of a debt specified in the agreement, or B. The deduction is required or permitted in terms of a law, collective agreement, court order, or arbitration award. So what that section is referring to is firstly that there needs to be a written agreement whereby the employee is agreeing to the specific debt, and this is subject to subsection 2, which I'm going to address in a moment. And then the second thing is, or this deduction is permissible in terms of a law, a collective agreement, a court order, or an arbitration award. Generally, what that is referring to is, for example, if there is a bargaining council collective agreement that requires the deduction of union subscriptions, then the employer will deduct the union subscriptions without there being a written agreement. Or it includes other types of deductions such as tax and UIF, or where the court issues an order to an employer to deduct a certain amount of money monthly from the employee's pay to pay it over to a third party. These are examples of deductions that are allowed to take place without there being a written agreement and without it being subject to subsection 2. Back to 34.1, where there can be a deduction if the employee agrees in writing to a specific debt to be deducted. And remember, this is subject to subsection 2, which I'm going to unpack now. 34.2. A deduction in terms of subsection 1a may be made to reimburse an employer for loss or damage only if, and there are 4 ifs. I'm going to take you through the 4 ifs. A. The loss or damage occurred in the course of employment and was due to the fault of the employee. So therefore, the first requirement for a deduction, other than that it be a written agreement, is that there needs to be proof that it was the employee's fault, that the employer suffered a loss or damages, and that it occurred as a result of the employee being an employee and being employed by the employer. Now the second requirement, 34.2b, the employer has followed a a fair procedure and has given the employee a reasonable opportunity to show why the deduction should not be made. Fair procedure here sometimes takes the form of a disciplinary inquiry, but it doesn't necessarily have to be so formal. Fair procedure just means that the employee was given a proper opportunity to explain why they shouldn't necessarily be held liable for the loss or the damage that the employer suffered. 34(2)(c). The total amount of debt does not exceed the actual amount of the loss or damage. And here I'm going to link it back to the question that we're addressing today. So let's say an employee does not give sufficient notice of termination and the employer is determining whether or not they comply with the requirements of the Act. Firstly, there might be some kind of written agreement that states the employee agrees that the employer will deduct the notice pay if they do not give sufficient notice. So let's hypothetically say that that is the written agreement. Then the question is the damage and the loss to the employer as a result of the employee and their employment? And in answering that question, I think yes, the employer's loss or damage is as a result of the employee not giving sufficient notice, and they're only giving notice because they are an employee. The second requirement of giving a fair procedure, the employer can invite the employee to an opportunity to discuss whether or not the employee should be held responsible for the loss or the damage. However, with the third requirement, it states that that amount that is deducted cannot be more than the actual loss or damage that the employer suffered. A different example that we see quite often with this is where an employee might damage the employer's vehicle in the course of their employment, and it is their fault and there is an agreement to that effect, and that vehicle is written off. In most circumstances, the employer doesn't lose the amount of that vehicle, meaning however much that vehicle cost. Usually what they lose is the insurance excess that they would need to pay. The employee would only be held responsible for the insurance excess that is paid by the employer and not the total amount of the vehicle. Bringing it back to this example, and my main concern when employers deduct the notice pay from an employee. When we quantify that loss or damage, it is unlikely, if not impossible, that that loss or damage will equate to the amount of notice pay. What that means is when an employee resigns, the loss or damage that the business will suffer might be in terms of sales or production or not being able to service certain clients or some variation of that. But quantifying that loss or damage, I'm not really sure how that will be done to show that the notice pay that is deducted is not more than the actual loss or damage that the employer suffered. And to show that it isn't more, the employer would need to quantify the loss or damage. In my nearly 6 years of being an employment relations practitioner, where, like I said, this happens on a weekly basis, I've not really seen a scenario where we were able to quantify the loss or damage that the employer suffered as a result of the employee resigning without giving their notice pay. I'm not saying there aren't situations where that damage or loss can be quantified. I'm saying I haven't come across any of those situations where we were able to truly quantify that loss or damage that the employer suffered and able to prove that it isn't more than the notice pay which is being deducted. And it is for this reason that I have my doubts around the fairness of deducting notice pay from an employee's final pay if they do not give sufficient notice. I probably should have mentioned this earlier in the video, but just to clarify, when I say deduct notice pay, I mean remove that amount, be it 1 week, 2 weeks, 4 weeks, or any longer period from the amount that would be paid over to the employee in terms of their outstanding remuneration or any annual leave that is owed to them. I'm not discussing the situation where an employer simply does not pay out notice to an employee who did not give sufficient notice. Of course, an employer would not be required to pay notice pay if an employee did not give notice when an employee hands in their resignation. And while it's probably not necessary, let's quickly look at the final requirement of a fair deduction. 34(2)(d). The total deductions from the employee's remuneration in terms of this subsection do not exceed 1/4 of the employee's remuneration in money. So if we were to ignore what I previously discussed and simply looked at whether this clause allows for the notice pay to be deducted or not, it might be possible, but also highly unlikely unless the notice pay is only 1 week and the employee is entitled to at least a month's outstanding remuneration and probably some annual leave. In any other case, if it were to be 2 weeks or 4 weeks or more, it's highly likely that it will exceed 25% of the employee's remuneration. And that concludes the relevant information about deductions to determine whether or not a clause such as an employer has the right to deduct notice pay if an employee does not give sufficient notice, whether or not that is or is not enforceable. And hopefully this video has equipped you to make an informed decision about whether you believe it is enforceable or not. Now I'm going to answer the question of what, in my opinion, an employer can do in the case where the employee does not give sufficient notice of termination, and answering the questions that employees might have of what will happen if I do not give sufficient notice of termination. Of course, in an ideal world, I would just like to tell employees to always give notice of termination, but based on what I see in practice, that wouldn't be realistic. So the first thing is, an employer does have the right to take further legal action against the employee to claim damages or to claim a loss. This might be a lengthy, costly procedure for an employer. However, this is not unheard of, and I do know of employers who have taken employees to court as a result of employees not giving sufficient notice. So the first thing that could happen is that an employer could take legal action against an employee for not giving sufficient notice and for breaching the requirements as per the contract of employment. It doesn't happen often, however, it is a very costly procedure should it happen. Usually this is enough to deter employees away from not giving notice of termination. The other thing that could happen is that the employer can tell any future prospective employers that the employee did not give sufficient notice. So basically, the employer would be allowed to, when phoned for a reference for that employee, disclose that the employee did not comply with the terms and conditions as per the contract of employment or the basic conditions of employment when it came to giving notice, and this might impact the employee's future employability. While I do understand that this is not necessarily a solution for employers who feel that they have already lost out, because the reason for the notice period is to give the employer an opportunity to find a replacement, to do a handover of the tasks and duties, and to ensure smooth running of the operations. And while this point does not solve that problem at all, it is my hopes that it will deter employees from not giving sufficient notice of termination, as it may impact their employability going forward. Therefore, to conclude today's video, my recommendation to my clients and to employers would be to not deduct the notice pay from an employee's final pay. However, you can come to a different conclusion based on the information that I gave in this video. And my other recommendation would be to employees to adhere to the terms and conditions required in their contract of employment and to give sufficient notice to the employer. And if for whatever reason an employee really cannot give sufficient notice, I would then recommend that they approach their employer, state the reasons why they're not able to give the notice period required by the contract, and hopefully the parties can come to some kind of agreement that ensures that that resignation from the employee doesn't cause damage to the employer's business. In my video on notice of termination, I discuss various agreements that employers and employees can come to. For more details on that, you can watch my notice of termination video. And that concludes today's video. If you found this information to be helpful or valuable in any way, please go ahead and like this video, that is helpful for me. And if you enjoy or find this content valuable, please go ahead and subscribe to my channel so that I can continue to bring you these videos on a weekly basis. If there are any specific employment relations related topics or questions that you would like me to address in future videos, please comment them down below so that I can know what you would like to see.